there are two principles to balance. On the one hand, there is the very understandable desire of patriarchs or matriarchs putting money's wealth into structures to plan for future generations, that it really isn't going to be in the best interests of the next generation to have access to information and to be aware of the wealth at a young age. And majority is 18, but for many people, the feeling may be that that just isn't the right age. And as Salpi said on the earlier panel session, it's very important for many families that the next generation is educated appropriately and that they're not distracted from their studies and any desire to focus on the pursuit of an independent career and get those values right. So on the one hand, we've got that concern, but on the other, as Steve and you, Stephanie, have said, there's the principle of trustee accountability, which is central to the trust concept. And it's really important that trustees are held accountable by beneficiaries, and so the argument follows that in order to be accountable, beneficiaries need to have information. And indeed, I'm sure many of the trustees in the room want that accountability to be there. It's also important that, as has been said, the respectability of Jersey and the reputation that attaches to the Jersey Trust is retained, not only so the trusts continue to be held valid in the island, in Jersey, but in other jurisdictions. So it's a very difficult balance to get right. And as Steve said, the provision in our trust law essentially hasn't been amended since it was introduced in 1984. But the wording has been looked at both by the courts and by a law commission in 1998, so 14 years after the law was first introduced. And the question was asked then, is there an element of ambiguity, uncertainty as to whether a trust instrument can be drafted to restrict rights to information? And it was felt that perhaps that the drafting could be clearer, and that although the principle of accountability should be maintained, it should be possible to restrict information rights in certain circumstances. Whilst that was the view of the Law Commission in 1998, the law wasn't changed. It was recognised then that there is difficulty in getting that balance right. And I think in the run-up to what became Amendment number 5, so in the consultation paper issued in 2008, the topic was discussed again. There was a mixed response at that time, and so no legislative change, and here we are now with Amendment number 7 and the consultation paper. And I think on the Working Party, Steve and I and others have discussed the issues and have felt, I think it's fair to say, that we feel that it would be helpful to clarify so that there can be a restriction in the drafting, a restriction in the access of information. But I think we all recognise the very difficult task that will amount to. And I think a point to make about our trust law is that when it was introduced in 1984, it was very much to provide a framework so that trust could be a sure and certain framework in relation to the validity of trust in Jersey, but allowing flexibility in drafting so that particular circumstances could be provided for, but allowing the courts to develop principles, fill in the gaps as circumstances change. And I think any move now needs to keep that principle at heart and not be overly prescriptive, cutting away the opportunity for future change.
I mean, Gilead, you can't help feeling, unschooled in this as I am. You've said, we've heard that this has been considered quite a few times and not done. Why now, or why do you think the balance might have shifted a little bit if this was something that was carefully considered and not done all the previous times?
Well, whenever changes are introduced, I start from the premise that nearly all progress is for the worse. So, in the words of Groucho Marx, whatever it is, I'm against it. I think the issue of restricting the rights or limiting the rights of beneficiaries to have access, to demand access to information about the trust and the way it's been run, is primarily market-driven. I mean, that's to say, it's something settlors like or think they like. But my perspective, and my work is virtually all contentious, is that that is very understandable as long as one assumes that the trust is going well. As soon as things start going wrong, it's very difficult to see any good reason why the beneficiaries shouldn't find out exactly what the trustees have been doing in order to enable them to enforce their rights before the courts, if need be, to have whatever's been going wrong put right. So from a litigation...
So that's putting that accountability...
Well,
right.
That's very much my perspective.
Yeah.
I mean, I don't have the task of trying to sell or persuade settlors to come to this jurisdiction rather than another in order to set up their trusts. I tend to see them when something has gone wrong. And if something has gone wrong, what is the justification for the trustees withholding it other than to protect themselves? And I think it's important to bear in mind when one's considering this issue that one is really only talking about the rights of beneficiaries to ask for information when there is no litigation on foot. A completely different set of rules applies as soon as proceedings have been issued, and the courts, the parties are obliged under the court rules to give disclosure or discovery of documents that aren't privileged, and most of this information, though it may be confidential, isn't privileged. They're nevertheless obliged to disclose that to the party that's bringing the complaint, usually the beneficiaries. So, provided the beneficiaries can formulate a claim which is sufficiently robust to avoid being struck out, and usually with a bit of ingenuity one can.
Well, they have you for that.
Yes.
They can then get access to whatever it was that the trustees were sitting on and possibly improve their case. I mean, the most extreme example of this I had was a trial at which, towards the end, I would ask a question, the witness would provide an answer, and I would make an application to amend the pleadings to rely on what he just said. And we went through that a number of times. In addition, there are provisions like the US 1782 rules, which enable the US courts to give parties disclosure in support of foreign proceedings, even if there are no proceedings taking place in the US. So there are other ways of getting the information. Freedom of information is another route that I've seen beneficiaries try and use to find out what's been going on. So from the point of view of ensuring that the trusts are properly maintained, properly run, and that the beneficiaries are enabled to enforce their rights, I would leave well alone. And so far as the infelicities of drafting are concerned, well, we've had a few court cases. Rabiotti has clarified one of the difficulties. To the extent that those problems persist, it seems to me preferable to leave it to the courts to sort out any ambiguities rather than try and rewrite it and possibly introduce some more issues to be litigated about.
I mean, Steve, I might also ask you the same question in the sense of, why it feels more on the agenda now, or seems to be having a slightly fairer wind this time than the previous times. I mean, is there a competitive aspect? Because I would have thought that would go both ways.
I mean, there is a competitive aspect, certainly, in the sense that if one looks at one of our competitor jurisdictions, namely the Cayman Islands, they have a form of trust. I won't get into the technical stuff, but they have a form of trust which essentially would allow for beneficiaries' rights to information to be restricted, provided there is somebody, a third party, a fiduciary, someone who has to act in the interests of the beneficiaries, called an enforcer, who has those beneficiary rights. And interestingly, we've seen that concept. So arguably there is accountability there because you have this enforcer who has the entitlement. We've seen this principle extended into the area of foundations. And for instance, in Guernsey, they have a requirement for a what they call a guardian to be appointed, where there are disenfranchised beneficiaries. So again, this idea that somebody needs to be able to hold the trustee to account. And I think from our perspective, I don't think, as far as Jersey's concerned, it's come up again for any other reason than we felt we'd not dealt with it satisfactorily last time, and a sense that now we're living in the era of foundations where it's perfectly proper for founders to limit the rights to information, that surely we must be able to create an environment where that was possible for trusts, albeit I fully accept Gilead's comments about how one is in a completely different landscape when there is litigation or proper claims to be investigated.